Commonwealth. John Nick, give me 10 seconds, shall be heard. Now, say the Commonwealth of Massachusetts, court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Judge Rubin. To my right, Judge Shin. To my left, Judge Ditkoff. We will be hearing 5 cases this morning, and we will. The rules are as they always are here. 15 minutes per side. There is no rebuttal. We have read your briefs with some care, and so you might want to get right into your argument, not waste a bunch of time telling us facts that we know, but on the other hand, it's your time and you may use it as you will. We will take our traditional mid-morning break after the 3rd case, and the first case we will hear, if I can find the proper slip, appears to be number 211174, Flexible Fundamentals, Inc. versus Beaird. And I'm sure I have the wrong counsel's name here, but I'm not sure. Do you have a bench slip? Thank you very much. We will be hearing first from Mr. Tochi.
Good morning, Your Honor. Thank you very much, Your Honor. It's a pleasure to be here this morning. I am John Tochi from Tochi & Lee, and I represent the appellants before you today, who are Erin McGrath individually and Social Perspectives for Everyone. The appellants appeal from an order of the Worcester Superior Court allowing a motion to disqualify counsel, my firm, from representation of the appellants in the case below. That case involved the enforcement of a non-competition agreement as well as counterclaims of breach of fiduciary duty and other claims as well. That case is ongoing. It's in the discovery phase, as is my understanding. Now, as the court is no doubt aware, a review of the order in this case is an abuse of discretion standard. But the Supreme Judicial Court has counseled that the courts must be mindful that disqualification of counsel is a drastic measure which courts should hesitate to impose except when absolutely necessary. Now, the Superior Court erred in many respects, both factually and legally in this case, and it wrongfully disqualified my firm from continuing its representation of the appellants as a result. And my firm had been the only firm that had advised Ms. McGrath in various matters, 3 litigation matters, matters involving fiduciary duties of closely held corporate officers, and also in a serious substantial audit for fraud of Blue Cross Blue Shield of their former company, Flexible Fundamentals, that had been ongoing for some time. I had represented Ms. McGrath in her personal capacity until disqualified in all those matters. Margaret O'Connell had represented Jennifer McGee.
You said all those matters?
Yes, Your Honor.
Who disqualified in the other ones?
I'm sorry?
Who disqualified you in the other ones?
I was not disqualified from any of the other ones, Your Honor.
So it's just this one?
It's just this single matter, Your Honor, yes.
Okay.
And Margaret O'Connell, for 3 years, had represented Ms. McGee individually, and critically, Flexible Fundamentals had been represented individually by Attorney White, Robert White of Bourgeois White, in those matters leading up to that time. He eventually resigned and left. Another attorney took over representation of Flexible Fundamentals, and now Margaret O'Connell also represents Flexible Fundamentals in all these matters. So I'm happy to focus my argument on any particular points the court may wish me to address. I certainly don't intend to repeat arguments. We feel we briefed them quite well. What I'd like to do, however, is emphasize what we believe to be some very salient factual points and legal points. And first, some significant facts that I believe are not disputed, for the most part. Obviously, there's no dispute that in 2016, my firm, myself, drafted a form non-compete, non-solicitation confidentiality agreement.
So why isn't that a client confidence, the date that you drafted that agreement?
The date that I drafted that agreement?
Why isn't that a client confidence?
Because it's a factual issue in any non-compete case. Well, actually, it's...
Wait, so if something's a factual issue in a case, it can't be a client confidence?
Well, let me put it this way, Your Honor. It's a non-factor in in the non-compete litigation because it's the date.
Not a factor. I thought you wrote in the opposition to the motion preliminary injunction that the fact that it was drafted on that day proved that some of the agreements were backdated and therefore unenforceable.
Well, that's the allegations below, right? The allegations below.
So you used a client confidence against your former client.
No, because there was no secret. There was no confidence.
What do you mean it wasn't a secret? Was it on your website?
All of the parties knew, the corporate actors knew, and Ms. McGee had told other co-workers that.
Wait, so let me get this straight. If a corporation's employees know a fact, it's no longer a client confidence in that corporation?
Well, if it's been revealed publicly, Your Honor, and if it's been revealed in court papers, no, it's not a public.
It was
confidence in
revealed
court.
publicly?
Yes, Your Honor.
When was it revealed publicly?
Affidavits filed with the Superior Court.
So in the litigation that you were doing?
Right, Your Honor, yes.
I mean, are you saying you can reveal client confidences in litigation?
No, I'm saying, Your Honor, that this was not a client confidence. It was not, well, it was not a significant factor in the case below, that is, the enforceability of these agreements.
I don't understand. That was one of your arguments opposing the preliminary injunction, so why is it not a factor in the case below?
What is a factor, Your Honor, is the dates the agreements were executed, which I had nothing to do with. That's what the factor is, right? And those agreements rise and fall with the Massachusetts non-compete, in part, the Massachusetts non-competition statute, which took effect in October of 2018. So the 2016 language is the language.
But I thought you argued that some of these agreements had to be unenforceable because they're actually dated before you drafted the agreement.
Because they were not updated when the statute passed. We had
But you said they must have been fraudulently dated because they were dated before you drafted them.
Oh, I didn't allege that, Your Honor. That's an allegation by one of the defendants, Ms. Beaird. She alleged that Ms. McGee told her that in 2020, that my counsel, Tom Conti of Myrick O'Connell, told me to get everyone's signature on these blank agreements from 2016, to countersign them, to backdate them, and to then give them all to him. That's Ms. Beaird's affidavit, right? There's also testimony from witnesses that the signatures that appear on these documents are not theirs. And critically, those factors have nothing to do with the terms, the conditions, and the language that I used in crafting this document in 2016.
McGee executed several 2016 agreements on behalf of Flex Fund, and she instructed several signatories to fraudulently backdate the agreements to April 7th and 10th, 2006.
16.
And then you wrote, the company, however, did not even have such formal agreements for execution until September 19th, 2016. So what am I missing? It seems like you're using the fact that you drafted it on the 19th to make an argument against the preliminary injunction.
No, Your Honor, it's the fact that those contracts were not updated in 2018. And again,
Well, that's not, that's,
the defendants are aware.
that's not what you wrote in this opposition. You did write this, right?
Well, I guess if a client confidence is owned by a defendant in the case, for example, Ms. Beaird, Ms. McGrath, and several of the defendants are all aware of this fact. Whether it's me representing them or another counsel representing them, they are informing their counsel that, wait a second, we didn't even have these agreements in September 2016, or in April 2016. We didn't get these until September 2016. And by the way, they were not updated when the non-compete statute passed in 2018. These are the same form agreements that the company used way back when. Right? This is known by all of the defendants. It was in all of their affidavits. And there was, of course, no motion to strike any of the affidavits or any of the pleadings that have been filed in the case below in opposition to the motion for preliminary injunction. Anything further, Your Honor? Happy to move on to that point. Okay. So I think it is important to recognize, and as the court below I don't think did, the lack of any involvement of my firm in further drafting any of these agreements. That in 2019, we had effectively stepped back from the drafting and of such contracts for the company. We had sporadically been involved in employment law advice from time to time, overseen by Myrick O'Connell, of course, again, as the record demonstrates, for example, updating a handbook, which was passed by all counsel before it was released. And again, the case below, it does not involve the construction of a single term of that agreement. That is, the construction of the language. It doesn't involve an ambiguity in the language that I had used in 2016. And it's apparent that the court gave great weight to the fact that obviously the case below involves a breach of contract, the breach of the non-compete agreement, the form I had drafted in 2016. But it didn't appreciate, I feel, and recognize some very important legal and factual points regarding the connection between the drafting of that agreement and, the underlying case, in this case, that is connecting the litigation and therefore looking for the conflict in the two representations. And again, the case below doesn't involve the interpretation of those contracts, all right? Contractual construction is not at issue. There's no attempt by the defendants to rescind the agreement. They're not claiming these agreements are void ab initio because of language issues. The battle over whether the agreements...
Well, what if there's an argument that no legitimate business interests support the agreements?
I'm sorry, Your Honor?
What if there's an argument that there's no legitimate business interest supporting the agreements?
It's a factual issue. The parties are going to, during the course of discovery, I imagine, are going to testify about what business interests and consideration were provided at the time the agreements were entered into.
So what's the difference between rescinding an agreement and arguing that no legitimate business interest supports it and therefore it's void?
No, I think rescinding an agreement is quite different. Rescinding a contract is quite different than saying, well, there are aspects of this contract that are unenforceable. For example, that would not affect the confidentiality provision of the agreement, right? Massachusetts is a blue pencil state. So the Superior Court, if it found that there wasn't consideration to support the non-compete provision because it was executed in 2020 and these parties were continuing employment under the new statute in October 2018, continued employment is not adequate consideration, right? But that wouldn't affect the confidentiality provision. The courts have the ability to blue pencil non-compete agreements in Massachusetts.
Obviously, I don't want to hear what advice you gave your client because of attorney-client privilege. But if you gave your client advice about the enforceability of this agreement, do you agree that then you would have to be recused from the matter?
No, Your Honor. If the advice was what everyone realizes and knows.
I don't know what that means.
Okay, well,
it seems to me, if you gave them a piece of advice that is now being utilized in any way, and I don't really fully understand and haven't gone into any depth on the arguments about enforceability one way or another. I mean, surely you would agree that there is something someone could sue your old client about where you couldn't represent that client, right? The new client.
I suppose depending on the facts.
Okay. Don't we have to, since we don't want to be asking lawyers in every case, well, what exactly advice did you give? Let's go have an in-camera hearing. We can find out the scope and nature of your advice. We're told that we're to assume advice was given, right? We don't want to know what you said to your client, but we have to assume something. Given that, don't you think that your argument cuts things too fine? We don't know everything you said to this client, nor do we want to, nor can we, but you did draft the agreement. Now someone is saying it's unenforceable. How are we supposed to, some cases, you say, depending on the facts, in some cases, Rule 1.9 would apply, in other cases not. How is that a manageable standard? Shouldn't we just, I mean, I'm sorry you won't be, if we agree, you won't be able to represent the new client, and they're sorry. They want to hire you, and you want to represent them. But how, without getting into attorney-client privileged information, are we supposed to parse these cases? Don't we sort of have to have a manageable blanket rule?
Two responses, Your Honor. The appeals courts, the Supreme Judicial Court, you're all about parsing. This is about finding a medium that reflects the public policy that we want to foster here, of the ability of a person to have counsel of their own choosing. In this case, counsel who had represented her in her individual capacity for 3 years and other matters, versus the release of confidential information. Now, this court is bound by the record. We have a record. We have 2 affidavits from the complaining party, Jennifer McGee. And critically, in neither of those affidavits does she even assert that any kind of confidential information was provided to her. And in drafting these affidavits, of course, she's guided by counsel. She's guided by Margaret O'Connell. So there is no allegation that I imparted confidential
I'm sorry, isn't all of your advice to her confidential?
Depending on the advice, right? If the advice was, for example, through a third party or not...
Okay, but you're sitting with your client, she's asking you questions, you're giving her answers. That's not public information.
Except in this case, Your Honor, there was no advice given.
I don't know. I don't want to know what went on between you and your client, but...
I didn't create the record, Your Honor. The record is the record. And if Ms. McGee failed to allege that I had provided some kind of advice to her implicating the 2016 agreements, particularly as it related to enforceability...
You drafted these agreements and you didn't give any advice to Flexible Fundamentals about them?
In 2016?
Never.
No, in 2016, and again, this is part of the record, the advice was, have your key employees sign these. 2019, Margaret O'Connell took over the management of these agreements, these draft agreements.
Your Honor, I'm sorry.
This is not the place to...
No, please, we don't, look, you're going to have an opportunity, and he's gone over time.
I've never seen an objection in the appeals court, Your
Would you please sit down? You don't have standing to object to something he's saying. You'll get to argue in a moment.
Privileged, Your Honor. That's the objection.
If it were privileged...
Oh, I see. Look,
I'm sorry, Your Honor.
we don't want to hear what advice you gave, and your time has expired. So we will give you an additional minute if you need it at the end as we've gone over.
I will, just to address Attorney Conti's allegation. This is in the record.
Okay.
Attorney Conti did not object to that inclusion.
We're not ruling on an objection. It's an appeals court. Your time has expired.
Thank you.
Thank you for your argument. It's very helpful to us. And we will hear now from, if I can get my act together here on this, Mr. Conti.
Thank you, Your Honor. Thomas Conti for Flexible Fundamentals, Inc., as well as Jennifer McGee. Your Honor, just to correct the record, in the record appendix, volume 1, there's on page 109, there's an affidavit from Ms. McGee. Ms. McGee states, to paraphrase, that Tachi and Lee was retained by Flexible Fundamentals for the period from 2016 until May 7, 2021, for the purposes of employment matters, and that Tachi and Lee drafted the agreement at issue. The reason I raised that, Your Honor, is because Mr. Tachi's comments about confidentiality are not appropriate based on the SJC case of Bays v. Theron. That case specifies, as Your Honors were indicating, in no uncertain terms, and if I may quote from the case, Your Honor, on page 691, it says, instead, he must prove only the existence of the tempting situation by showing, 1, that an attorney-client relationship existed in the former legal representation, and 2, that the former and current representations are both adverse and substantially related. Flexible fundamentals only had to show that there was an attorney-client relationship. Once there's an attorney-client relationship established, it says, the case says, thus, the substantial relationship test operates by assuming that confidences were transmitted in the former attorney-client relationship.
Right, but you'd still have to show it was substantially related and adverse, right?
Absolutely. So adverse, Your Honor, we have a current lawsuit between Mr. Tachi's former client, Flexible Fundamentals, and Jennifer McGee, and his current clients, McGrath, and it's not just limited to McGrath and Social Perspectives. I would call your attention to Volume 1, which has page 132, which has Mr. Tachi's emails saying who he represented. Erin McGrath, Lindsay Beaird, the person whose affidavit he was referring to, Travis Turner, and Social Perspectives. Those were the clients he was alleging he wanted to represent. Those were all adverse to Flexible Fundamentals. So you have the adverse relationship, now substantially related. You have the same agreement. It was an agreement that Tachi and Lee drafted that's undisputed. He said it again. He's claiming it's a form, it's attorney product that was paid for. And now we assume there was, by virtue of the Brace case, we assume there were confidential communications between...
Could you tell me which of the individual defendants were management level employees of Flexible?
Yes. So McGee was a shareholder and 40% owner. She was the president of...
She's the plaintiff, though, right?
She's the plaintiff.
Now, which of the individual defendants were management level employees of Flexible Fundamentals at one point?
McGrath was a 40% shareholder, Your Honor, and also the vice president, treasurer of the organization, and was a founder of the organization. And she is the person who formed Social Perspectives. She's listed as the manager for that entity, which, according to the Secretary of State's information, provides behavioral services to children, which is the same business line as Flexible Fundamentals. Okay. So my point, Your Honor, was...
What about Lindsay Beaird? Was she a management level?
Lindsay Beaird was a supervisor, but did not own stock in the corporation, and was the daughter of Jennifer Beaird, who was a founder of the company and a 5% shareholder.
How about Travis Hopper?
Travis Turner, Your Honor?
Hopper.
Travis Hopper was not a management level employee, and neither was Travis Turner.
And what about Sarah Roberge?
Sarah Roberge also was not a management level employee. She was a supervisor at BCBA, they're called, but not a management level employee.
All right, thank you.
Sure. So, Your Honor, as far as the substantially related, Tachi and Lee drafted this agreement, and it wasn't just a non-competition agreement, it was a confidentiality, non-solicitation, non-competition agreement. And now, and in 2000, Tachi and Lee were called upon to attempt to enforce this agreement against a former employee. Her name was Kristen Bianchi. And they sent a demand, Tachi and Lee sent a demand on behalf of Flexible Fundamentals, and that was in 2020, Your Honor. So you have the initial engagement in 2016, here they are in 2020, attempting to enforce the very agreement that's at issue here. saying they represent flexible fundamentals. Now, fast forward to September of 2021, Flexible Fundamentals filed this lawsuit to enforce the terms of the agreement against these employees who had left the company and were engaged in what is alleged to be solicitation, accepting work from clients and former clients, hiring employees and former employees, and competing against the company in Worcester County. It had agreed to refrain from those activities for a year following the termination of employment of each employee. In addition, you mentioned earlier what I would term as goodwill. That is also a requirement under the agreement, and that is that the goodwill of Flexible Fundamentals belongs solely to Flexible Fundamentals, didn't belong to anyone else, and that's client relationships, referral sources, training, methods of treatment, et cetera, et cetera. That also constituted confidential information pursuant to the agreement that was drafted, and that if it were released, it would irreparably harm Flexible Fundamentals. So now you have this lawsuit over this agreement. Mr. Tachi's former client is Flexible Fundamentals. Previously, he had engaged in providing services to Flexible Fundamentals and produced this agreement. He had even sought to enforce the agreement, and now he wants to be on the other side, and he wants to contest the enforceability of the agreement. That is an intractable conflict under 1.9A of the Rules of Professional Conduct. It can't be more clear than that. And as I believe Justice Rubin said, we have to have bright line rules. That's why we noticed the conflict. We asked him to recuse himself. He wouldn't do it. This then went to, what he did is he moved to stay after the Superior Court rendered a decision. And it went to Justice Englander. And Justice Englander addressed the motion to stay, denied it, but also looked at the underlying case because his decision is reflected on the docket, which is part of the record, and it says, he notes there's not a strong likelihood of success on the merits for Tachi and Lee's claims. And that
when a single justice is not looking at the stuff we're looking at, those are done with preliminary briefing, and they don't have he doesn't have the whole record that we have, or the time that we get.
I understand that, Your Honor, and I'm not implying that it's precedent. I'm just saying it's another distinguished jurist who has looked at this and has said there's not a strong likelihood of success on the merits. And what I would maintain, to Your Honor, is that under 1.9A and the comment, this is 25. They pushed this through the Superior Court to the single justice all the way here, and it's still the same issue. He wants to switch sides, and that's prohibited with respect to the same agreement he drafted. Subject to your questions, that concludes my presentation.
I see no further questions. Thank you very much. Your argument has been very helpful to us as well.
Thank you, Your Honor.
The case is submitted.
Thank you, Your Honor.
We will turn next to number 22-002, Gorelick versus New Albertsons, Inc. And when you're ready, we will hear first from Attorney Duggan.
Thank you, Your Honor.
May it please the court, my name is Christopher Duggan, and I am here on behalf of Stanley Access Technologies. This case presents really two issues for the court to decide. The first is what was Shaw's obligation to prove to recover defense costs under a purchase and sale, the terms and conditions of a purchase and sale agreement for the installation of these automatic doors at a store in Chestnut Hill. And the second